Good morning, Director, sir. Good morning, Deputy Director. All my technical staff who is here, all my colleague judges from the trial judiciary. On this twin topic which has been given to us, you may close down your books for the time being. You may close down everything because what I will be doing it, I have not shared it with you. Otherwise there is no charm, Everybody can read. We are not law students. I have always believed that going to an academy, we only interact, we exchange our ideas and thoughts. Because we are judicial officers. This is my first purpose, that I give something which I know, you give me back and your colleagues what you know. And at the end, we can clear our cobwebs. Say, at the outset, both the topics you may feel are not interrelated. Why these two diverse topics? The diverse topics because since 2018, the Supreme Court has been feeling that we are neglecting the core purpose of criminal justice delivery system. What is this core purpose? Say in our student days we read everything, retributive theory, then you have to have corrective measures. When do we have all this? When? You can have this at the end of the trial or a suit. See, we don't lay much emphasis on witness protection under the civil jurisprudence, because at times they are not intimated. But under the criminal jurisprudence, many don't like going to the jail. And therefore, a guideline was prepared in 2018 for protecting these witnesses. Say, in a democracy, there are three limbs as we have been taught: executive, the legislative and the judicial branch. Now out of these three, all three feel we are powerful. Yes, but the pivotal role is played by the judicial process. Why and how? When the executive or the legislative wing acts in excessive of their powers, the judiciary steps in. For what? For interpreting whether the act is excessive or not. Who will guess? Who will gauge whether it is an excessive power exercised by the government on its legislative side or executive side? Therefore, the pivotal role is by the judiciary. Now, judiciary, according to me, like your heart, has several veins and arteries which lead to its living. कहते ना आपके हार्ट में ब्लॉकेज है, इट्स अ मिसनोमर. हार्ट में कभी ब्लॉकेज नहीं होता है, ब्लॉकेज आर्टरी में आता है, which leads the pure blood to your heart. If you recollect your school days. So there, if there is a choking, the system will collapse. At the end of the day, what do you say? No evidence, acquitted. Where does this evidence come from? Who gives you this evidence? Who gives you this evidence? Where is it defined that who will come with the evidence to you under the CRPC? Or now the new Bharatya Samhita. See, in a recent lecture where I had been to Chennai with a colleague of mine, see, though the law has come in July, for you and me, one of the lawyers told me, sir, अभी मैं बहस कर रहा था, and I hope you all understand Hindi to some extent. मैं बहस कर रहा था और जज साहब को मैंने कहा कि सर नए संहिता के मुताबिक 302 का मुकदमा है. The judge said, I don't want to hear you, rejected. Why? Why? See, still we are over enamored with our old law. 302 मतलब khatam. Then the fellow had to explain कि sir, I am talking about the new Samhita. Please, let's go to the new Samhita. It's not that rigorous a punishment. So, and for me today also, as a retired person, I don't want to read the Samhitas. Why should I now read? Unless I want to go to the academy. Because for me 439 is anticipatory bill. $438, sorry. I am sorry. Age is catching up. So, where do we get all this? Then, at the end of the trial, you convict somebody, the matter goes to the higher forum. Higher forum says, yes, we concur because there is chain of circumstantial evidence. Here there is unfortunately no eyewitness. Then how do you get to things? What is circumstantial evidence? That's not my topic, but I am just touching it so that a broader perspective can be got about what we understand by the word evidence. Witness is a person, according to me, who comes with evidence, who testifies before you something. You see, as we know, and in your day-to-day life also, I am told yesterday by my colleague here that the crime rate in Sikkim is minimal, unlike other states. So when this was given to me, protection of witness under special legislations, I said, आपके यहाँ तो NDPS का crime ही नहीं है तो सब कैसे करेंगे? He said, नहीं सर पढ़ाना तो पड़ेगा because of the Supreme Court and the National Judicial Academy narratives. Fine. So why such special treatment to those witnesses? What for? Say POSCO. We have come across POSCO. Why that? Because they tend to be more vulnerable. That is not the only reason why they should be protected. But the purpose of their protection is manifold. One, a minor can be lured into many distractions, can be scared, can be intimidated, intimidated. In that case, you need to protect these witnesses. Now, sorry. See, when we gave the constitution to ourselves, what was the fundamental thing which we wanted? Justice to all. We the people of India resolving to secure inter alia justice, social, economical, political, to all its citizens. And therefore, you see, if you read any of the texts, you will find that justice is placed at a higher plane than liberty and all other isms. Justice takes a higher pedestal in this hierarchy. And it is in us where the faith lies of the people. See, if you see your not childhood days but young days, you don't have a quarrel, but somebody swindles your money. You don't tell him that I will see you in the parliament. You don't tell him that I will see you before the collector. What is the word? तेरे को कोर्ट में देख लूंगा. आप कोर्ट में मिलते हैं. Why? Why this? Because as far as the courts are concerned, they have a duty enshrined in us. We as judges, the duty is enshrined in you. And who has given you this duty? Is it the government of India? Who? Can somebody tell me? I'm not talking about atheists. Those who believe in God, I believe that it is the Almighty who has given these powers to you. Why? Why this? 130 करोड़ की आबादी है ना, कितने की आबादी है इंडिया की? Somebody? You may not sit as moot spectators. Please open up. ये आपके ACR में कोई लिखने वाला नहीं है. This is not going to go into your ACRs. So don't be scared. Now out of that, you have been selected. What is the population of Sikkim? 7 lakhs. Out of 7 lakhs, you are 12 sitting here to do justice to the people of Sikkim. Why? As I told you, justice at the highest pedestal. If the witnesses are not protected, what happens? Are you going to do justice? What will you say at the end of the day? Kya kare sir? If the district judge tells you, Madam, आपका कोई conviction rate ही नहीं है, क्या करूँ sir? They come, get the offence compounded, what can I do? The witnesses have turned hostile. Therefore this scheme. Now, is the term witness defined in any of the legislations? Can somebody tell me? First thing, how many of you say that it is defined? The word witness is defined in which section of the old CRPC or new Samhita, or the New Evidence Act, or the CPC as you say?
I think it has not been defined.
How many agree with you? How many of you agree with her? You are not agreeing. Then please tell in which section it is defined. Because you are the sole person telling it is defined somewhere. Where is it defined?
I have not said that.
Then you didn't raise your hand.
I didn't raise my hand.
So that means that you are not agreeing with us. How many of you say that the term witness is not defined in any of the acts? Any of the legislations? Please raise your hand.
Lordship, I'm not sure, but I think Indian Evidence Act does define competent witness under 118.
I am not on competent witness.
Witness,
The only word is, see, we have a general proposition. Witness. Witness.
I'm not sure, Lordship.
No, if you're not sure, let's go to the act and see it.
Who may testify?
Hmm?
There's a chapter who may testify under the Indian Evidence Act. Who may testify, that chapter is there under the.
Who may testify is a different issue at all. But the term, say like in your criminal manual, if you take it, CRPC or IPC or, there you have the definition, section 2 defines certain terms, right? Say for your benefit, let me tell you, unfortunately, the new Samhita also does not define. Who will be a witness? Who will be a witness? There are reasons for not defining the same. Because an accused can be a witness against himself. Why and how? Say recent judgment of the Supreme Court, if you subscribe to Live Law, there the Supreme Court said that if it is a statement under 164, retraction thereof will have to be seen with minute eyes. You cannot discard what he has testified before the magistrate. It's not like 161 that it's a statement before the police. He cannot retract saying that, sir, I was under coercion. Before magistrate, what coercion was there? You have given that testimony. See, many of us, the 90% of us, refuse to become witnesses. Why? Your ordeal starts from that day. Why? Even a victim at times is reluctant to come to the courts. Why? And you can take this, before 3 decades the Supreme Court has deprecated this. Delhi Domestic Working Women's Forum, you may note this if you want. Because I don't, like other research scholars or resource people, I don't stuff you with all high grade things which make you bored at the end of the day. I make things light so that you may remember things, so that it's lively. आपको ये ना लगे कि ये लेक्चर कब खत्म होगा. There were some, no, that you feel like going for a nap. Delhi Domestic Working Women's Forum versus Union of India, 1994, 3 crimes, 597. In 1995, 1 SCC, page 14. Now why this? Why this pain the Supreme Court has shown? It could have decided the matter and finished off. No. The Supreme Court was at pains to write like this, and I quote, the victims, this is especially for trials of sexual harassment. The victims have invariably found rape trials a traumatic experience. And therefore, you see, recently, before the new Samhita came in, you have an amendment to the Evidence Act. You cannot put certain questions to the prosecutrix which will cast an aspersion on her character. That is an added proviso to section 146 of the Evidence Act. If you want, you can vote it. I hope I am audible to all of you. I am audible to the victims have invariably found rape trials a traumatic experience. The experience of giving evidence in court has been negative and destructive. The victims often say they considered the ordeal to be even worse than the rape itself. See, now understand the trauma which they face. The court should disallow any kind of scandalous questions. You may stop it, but the putting of the question itself, do you not think will cause a trauma to the person? Say for example, if I tell somebody sitting here, मैडम आप ठीक नहीं बैठे हो, ये क्या तरीका है बैठने का? See, even without naming anybody, telling this with a loud voice will send ripples to 1, 2, 3, 4, 5, 6, 7 of you sitting here. किसको कहा? मैं तो ठीक से बैठा हूँ. You'll start seeing here and there whether I'm sitting properly or not. So this kind of a question itself should be nipped in its bud. The moment the lawyer tries this, yes, if it was in the FIR, then fine. If it has come somewhere in the examination in chief, it's fine. Otherwise, it is scandalous. And now, add opposed to the proviso of section 146 of the evidence. मैडम ने कुछ किताब मंगवाया है, कुछ हमें भी ज्ञान दीजिए.
Sir, I was looking at 146.
The proviso. See, proviso 146(3). I'll also read it out for you. Okay. You have the old book with you or the new manual?
New manuals.
हाँ, तो उसका corresponding देख लीजिए आप पहले. It is there in the new act. So at times now it is high time that you'll have to draw the attention of the lawyers to what is there, what was there in section 148 to 152 of the Evidence Act. Now one more aspect apart from this topic, say Samhita came into, all these three acts came into force in July, right? You have a criminal trial pending since 2019. Which act will you apply? Right? So therefore, at present, for the time being, you will have to have recourse to your old act for your trials to be there. You cannot say that no, even to the old trial I will apply this new law. Unless you get a verdict from the High Court or the Supreme Court saying that normally all procedural laws cannot have retrospective effects. That is very clear. Now you see, there may be a person whom you want to call as a witness, but you are requested not to call. See, you may feel कि ये क्या कह रहा है, ये कहने के लिए इसको यहाँ बुलाया है गुजरात से. See, why I am telling you this? There are kind of witnesses whom you may not summon. Who are they? Depositions of medical witness taken and attested by magistrate in the presence of the accused. Do you get me? Where the document is to be produced before you, which is by a medical witness, saying that when I saw the accused, there was, say I am talking about the special act now, there was profuse bleeding on his vital part. And that has been testified by the concerned magistrate. Yes, fine. So then also do you need the doctor to be examined, put to cross-examinations? The Act says no. Report of a gazetted officer of the Mint. Report under the hand of a scientific expert. Sorry. I missed out one small aspect on deposition. I'll take it later once I'm finished with this. Document of the identification in the hand of an executive wound certificate in case of simple hurt. I don't tell that. Don't call witnesses where there are multiple injuries. Simple hurt, yes, it is there. The magistrate should avoid calling such witnesses. Say for example, before a few days, I got a summons in name of my predecessor. My office contacted the learned concerned magistrate. It was a decade-old case. He said, "नहीं, साहब को आना ही पड़ेगा." The audacity of the staff, not the judge. They first interacted with the staff. तो बोले तो आप ऐसा कीजिए, जाके लेके आइए उनको. My staff was also rude. आप जाके लेके आइए. he is no longer with us and we don't know where he is, whether he is in Swarg or Nark, aap jaake leke aaiye. The poor fellow tells him, my staff, he is not alive. Then also he insists. The ministerial staff. Then I said, तुम उससे चर्चा ना करो. Tell the magistrate to talk to me. I said, sir, वो उसने कुछ देखे बिना समन्स निकाला है, देख लो. He was really polite fellow. He said, sir, मैं देख लेता हूँ. I'll get back to you. He said it was a report by the then Human Rights Commission chairman, on the basis of which the FIR was lodged. He said, sir, I don't need it. In the charge sheet his name was there. Therefore these people, होता है ना, charge sheet पे जितने हैं बुला लो. You must also be doing it. Charge sheet पे जितने हैं सबको बुला. Call all the witnesses. Now we go to the overview of the witness. Why do you need this scheme? Who is a witness? Any definition you can give? You can give.
Any person who comes before the court to testify or to produce any document.
This document, what would it be? Let us be more specific about document. What word you will use as a legally trained mind?
In case of document also?
Instead of the word document.
Documentary evidence. Documentary evidence also.
A witness, if you want you may note it down. A witness is a person who provides A, evidence. B, deposes before a judicial tribunal. Now don't say कि sir, we are not tribunals. Judicial tribunal means what? A justice delivery system. It's a broad-based example given to us. Now Supreme Court in Ritesh Sinha versus State of Uttar Pradesh simplified this word and said, in its ordinary grammatical sense, anybody giving oral testimony was a witness. Now don't tell कि sir, nowadays it's on affidavit. What is an affidavit? Now this question was asked to me when I went to some other law college. What is an affidavit?
It's a sworn statement.
Say what's an affidavit these days under CRPC or the Evidence Act? And why was it coined? See, broadly defines. Witness is a person who has witnessed conduct or is able to provide anything which may be of relevance in relation to which he has been called to give evidence in a proceeding. Why this absolute elaborate definition? If you want, you may note it down. If you want, I can pass on this to you. Choice is all yours. Then he goes by the dictionary meanings. one who gives evidence in a cause, you know, I may come and tell you anything. I am not a witness. It has to be a cause. There has to be a cause. आप पे कोई झगड़ा नहीं है, फिर भी you are not going to call any witness. In your daily parlance, at the end of the day, say, what are you going to tell? Sir, देखिए, he was a witness. One who sees, knows, or voices for something, or one who gives testimony under oath. Say, what is affidavit? What do you understand with the word affidavit?
Sworn statement.
It is basically a deposition in place of oral testimony so that the judge's time is saved. He prepares his testimony at home, gives it away to the other side much in advance. When I was a judge of the family court, we didn't have these rules. And section 125, as you know, is covered by CRPC. Though it is considered to be quasi-civil. The lawyers objected. Sir, हमको affidavit पे नहीं. Okay. I told the lady, come in the box. बोलना शुरू कर दीजिए आप. No, sir, I need time. No, now not. You see, why are we judges at times becoming strict? See, Harry told me कि sir आज affidavit दिया है, मुझे एक हफ्ते का time दे दीजिए. I'll prepare myself. Instead, taking all these objections against this witness, deposing in a particular manner, what is the importance? Why? As I began with the prelude, at the end of the day, you will say कि sir कोई witness ही नहीं था. No witness came forward. What can I do at the end of the day? I have nothing to do now. He is a vital guide in the criminal equities framework. Say the foundation of the trial. As I told you, if you are a victim, if you are a complainant, at the end of the day, what matters? What matters is your dealing with the matter. Money power, muscular power, political power, self-generated fear of police. तो you may see ऐसे कि सर witness को पुलिस का क्या fear होता है? Unsympathetic law enforcement machinery, corruption, protracted trials. Why protracted trial is a threat to the witness? What for? So वो तो आज आया, कल भी आएगा था. See, your memory fades. I'll give you one example where I issued a bailable warrant on a police official who was supposed to come and depose, as he was the person who had investigated. He didn't come. So, bailable warrant was issued. This poor fellow comes. When after his bailable warrant was cancelled, he sought audience with the government leader. I said, okay, let him come. This is what I am telling hassles faced by the witnesses during investigation and trial. I'm talking about trial now. He said, sir, आपने वारंट निकाला, कोई दिक्कत नहीं. I came here for 16 times. Sat from morning 10:30 till 5:30. Under one pretext or the other, I would be sent home. I was the only last witness to be examined. But the judge would not examine me, despite both parties being ready. So my government pleader told कि जब तुमको नया समन्स आए तब आना. I had a hearty laugh. What else can you do to a litigant, to a police official? Why should you make him come and sit from 10:30 till 5, and then on a lighter vein the judge would tell him, आज आप बहुत थके हुए दिखते हो. तो भाई क्या करेगा आदमी? 10 बजे से बैठेगा 5:30 बजे तक बिना चाय के, तो थकेगा नहीं तो क्या करेगा? तो आज आपका अगर एविडेंस हुआ तो गलत हो जाएगा. नेक्स्ट टाइम, नेक्स्ट रीजन वाज, मैं बड़ा ज्योतिष देखता हूं. अगर आज आपका डिपोजिशन हो गया तो इट विल गो इन फेवर ऑफ द एक्यूज्ड. सो आज आपका नहीं लेते. Said, sir, I came for 16 times. Pardon me. And you on my first date when I came at 10:30 took my evidence, and therefore I waited to meet you till 2:30, till you rise. I said, that's good of you, but the last, non-existence of any clear-cut legislation to check hostility of witnesses. Now you see what happened is, if you are aware about that famous Zaira's case, I'll take you to that. They are all witnesses in that Best Bakery case, if you read it as students. It's a 2002 judgment now. All turned hostile. Now the Supreme Court laid guidelines on hostility also. See, reluctance to appear, retraction from their earlier, miscarriage of justice, and vitiation of trial. At times the witnesses say कि सर हम आए तो भी क्या होगा? क्या होना है? कुछ नहीं होना. Now why do you need this witness protection laws? And what is this scheme? Why did you have to float a scheme? And what are the best ways you can protect them? Can somebody tell me? What are the best ways you can protect them? Can somebody tell me? See, at times we take witnesses for granted. You don't pay attention to any right or needs that they may have. Though they are so crucial for your justice delivery system, you tend to neglect them. And therefore this scheme. The international standard also, they have this Witness Protection Act. USA, Australia, we did not go deep into that. Say crimes would be committed time and again. So the victim of that crime has to get some reprieve, which is our next topic. So for that, you need to protect this witness. Say, I am complaining of maltreatment. But if the witness says, no sir, मेरे को तो कुछ ऐसा लगा नहीं, then where does the victim stand? I go crying. I don't get justice. Therefore this, UN conventions, now the next topic which I have, we'll take it later on. Now remove your focus from there. Now you have three kinds of threats. नहीं मैडम 11:30 सबके साथ ले लेंगे. You have given me a break of 10-12 minutes, no? So that's better. Categorization of threats. Category 1, 2 and 3. ये यहाँ नहीं दिखेगा. So remove your focus from that. That I'll take it in the next topic. Protection of witnesses under special legislation. Yet I want this first overview of the scheme, you know. You have three kind of categories. Where the threat extends to life of the witness or their family members during and after the trial. That is category A. B, where the threat is related to their safety, reputation or property. And C, moderate threat, mostly involving harassment or intimidation. So if the crime which is complained is not of that high magnitude, the intimidation will be less. If it's a crime under 323, you are not going to kill him. You will first try कि भैया 323 है, except the Ankush Gaikwad theory, take compensation, because the words are may, punishment or fine. So there is moderate threat. Confidentiality. The scheme ensures that the identities of witnesses are protected. Why identities are protected? So when I was a law student, nobody told me not to write the name of the prosecutrix. Then this law was developed by judicial way, judicial proprietary, by the precedents, that in case of rape you will not name the prosecutrix. In cases of POSCO, the victim will not be named in your judgment. Witness Protection Fund has been established to finance the measures under this scheme. This is founded by budgetary allocations from the state government, fines imposed by courts and donations or contributions from philanthropists or charitable organizations. Now, what protection can you give? What kind of protection? I have asked this question. One by one, if somebody can tell. Yes, madam.
If there is certain rules at place, we can always implement those under the witness protection.
No. What type of protection will you give? As a judge, what kind of protection do you suggest?
For the witnesses,
Yeah.
they shouldn't be harassed by the accused.
एक second. I just asked.
This is the witness of the
Okay. Yes.
In case
if there is a severe threat to the witness, then maybe relocate the witness after the trial.
Yes, yes.
To keep her in proper safe place before taking the
Along with the witness, maybe the witness's family should also.
Yes. Yes, madam.
Would an in-camera trial?
Fine.
Should maybe an escort is given at witness's house?
Fine. Yes, madam.
During the trial, maybe not putting witnesses through the unnecessary question by the defense.
Yes. Okay.
Providing congenial and
Fine. Congenial atmosphere. See, all these points are there in the scheme of 2018. Say, changing the witness's identity. One of you told that. Second, relocation. Concealing the identity in the court. Nobody told that. What is concealing the identity? How do you conceal the identity? See, you bring the witness, say have a barrier between the witness and the accused where this, we have this, no, vulnerable witness schemes are there now, where you have those policies. Yes. Security escorts is told from the place where they are there and to the court and back. Now, what are the limitations? Can somebody tell me? What are the limitations of this scheme? If some of you have read the scheme, how many of you have read the scheme? Don't feel shy. How many of you have read this scheme? If nobody has read,
Read but about a year back.
I had not read till sir told me that I have to take a lecture on this. I then mugged it up. Now, what are the limitations of this scheme? So then, sir, thank you for this topic, because most of us were not aware of this scheme of 2018. We had the broad idea of protecting the witness. Now the Supreme Court and all the governments, the Gujarat government has come out with guidelines. I could not find any guideline by the Sikkim government for witness protection. Victim compensation, yes. Say many states are slow in implementing this scheme. Say, what is our basic difficulty? I want to safeguard the interests of the witness. I don't know the infrastructures of, I don't know the infrastructure of the courts in Sikkim. But Gujarat, things are worst. At times, UP and Gujarat, there were no infrastructures. So when you don't have infrastructures, it is very difficult to implement this scheme. Lot of lack of awareness programs, You don't have these awareness programs whereby the witnesses can be told. Then there is lack of funding. The government may not give you the funds. As I told you, there is inconsistency as far as the districts are concerned in a state also. Now, why do you need this witness protection scheme? What for? विटनेस तो कल भी आते थे, आज भी आते हैं, उसका क्या है? आता है, आना है तो आए, ना आए ना आए. Why do you need this? What is the need for this? Say, as I told you in the beginning, they are the pivotal persons in the scheme of trials. And therefore, if you do not protect them, permit them to be intimated, your purpose of this criminal trial is going to go haywire. सर, आपका बंद हो जाए तो मुझे कहना, आपका वीडियो बंद हो जाए तो मुझे कहना. हाँ, इट डिस्टर्ब्स मी हियर. अब बाहर जाके सुनिए ना, कोई दिक्कत नहीं. हाई रेट ऑफ विटनेस हॉस्टिलिटी. दिस इज वन ऑफ द थिंग्स विच द लॉ कमीशन विटनेस्ड. And as I told you in Zaira Sikh, 2004, way back, means 2 decades, the court acknowledged that hostile witnesses often result from intimidation and recommended the establishment of a comprehensive witness protection program. This was one of the pivotal judgments. Zaira Sheikh. If you are aware of the facts, what happened is post train burning, there were about 58 people who were chaired to death. There was an aftermath in Gujarat. Now in this riot, this bakery known as Best Bakery, where people lost life. This Zaira Sheikh did not depose. The matter went up to the Supreme Court. There she told that I was intimidated. And thereafter this entire trial was transferred from Gujarat to Maharashtra with all these reasonings, hostile atmosphere to the witnesses, laying down guidelines. Now in 1994 or 5, I am not exactly remembering the year, on 15th of August, a person comes to the podium when the sitting MLA was hoisting the flag, shoots him down, point blank. All the witnesses who were there turned hostile, except the police witnesses. Now the High Court of Gujarat said, no, we'll convict you. Maybe the trial court has, in the Supreme Court, they said that the testimony of police official, importance of that. At times we are told, were you at the scene of offence? No, sir, I was not. Okay, fine. You are the investigating authority. Okay, fine. Now here, the police officials had caught this Anirudh C from the spot with his pistol. So can you say they were only investigating police officials? The Supreme Court says no. State of Gujarat versus Anirudh Singh. It is a 1997 Supreme Court. You may note this. It is even good for your academic knowledge, where you may not rely solely on hostile witnesses.
Kindly repeat the citation.
It is State of Gujarat versus Anirudh Singh. It is 1997. It's a Supreme Court judgment. And Zaira Abibullah Sheikh versus State of Gujarat. Many law commissions, because in India, if you see in many of the cases, these witnesses turn hostile. So the 154th, 178th, 198th report have all emphasized on protection of the witnesses. Say Indian Penal Code as it was, section 195A, if you read it. Juvenile Justice Act, POSCO Act, and the Whistleblowers Act provide safeguards for the witnesses. I'll take you to that now. That's protection of witness under special legislation. Sorry. Right? Unlawful activities, section 44. Notwithstanding anything in the code. Which code? What do you understand by the word code? Right. Visas to be recorded in writing, be held in camera if the court so desires. Second, National Investigation Act. There also sections are there. Subsection 2. This is Maharashtra, you may skip. Now section 195A. Penal Code. Disclosure of identity of the victim. Why his lordship has taken victim here? Is victim not a witness? He or she is a primary witness, no? Evidence Act. I took you to the Law Commission's report. Now comes the scheme. I have already discussed category A, B, C with you. Fund I have told you. Threat analysis I have told you. Change of identity we have discussed. Now measures. मैं थोड़ा ये बाजू करना पड़ेगा. Is it proper? The last one. Other miscellaneous measures may be taken up at the request of the witness. What would be the request? Witness को हम कुछ बोलने देते, कुछ request करने देते. So under the scheme, please at the end of the day tell him, is there any threat? Do you want any special things to be done for you? That is what the Supreme Court wants the judges to do it. We have already decided. Are you people able to read this?
Yes.
Neelam Katra. It's a Delhi High Court judgment. Zahira Sheikh, I didn't have the citation, you can take it. 2006 2 SCC. Page 374. Bentham said witnesses are eyes and ears of the justices. I call it their eyes. I call it their veins and the arteries of the justice system. What happens if there is a blockage to your arteries or veins? You're gone. Maybe he's an 18th century author, I am a 21st century author. We'll take this in the next topic. You even have, apart from what his lordship has said, I have 4 more topics, 4 more legislations. There is one main legislation which many of you must be dealing with, Juvenile Justice Act. Most of the judicial magistrates would be dealing with Juvenile Justice Act. Do you deal with that or not? So here you have specific judges for the Juvenile Justice Board or not?
Only the magistrates will complete it 3 years of.
But he or she will be on the board as the chairperson of the Juvenile Justice Board. Section 21 is very clear on that. Then POTA was repealed, therefore we may not go into that. POSCO has it, which most of the appellate judges would be dealing with. I discussed the National Commission also. The Police Commission also has time and again said this. Say one more aspect, the daily allowance which we give to a witness. No, we may not go into the meagerity of it. Say what happens at time is, a witness doesn't like to come. Say for example, the punch witness. You understand the word punch? Because at times dialects may differ. So at times a punch witness would not like to come. Why? Say the panchnama is drawn at the place of the offence. So any tender by or parcel by is taken up by the police. Sign karo is pe. Now when your summons goes, is a daily wager. From morning to evening, see there is a mindset in the humans. कोर्ट में तो मुद्दत डेट पे डेट लगेगा, बहुत जाना पड़ेगा, सवेरे से शाम को बैठो और फिर जज बोलेगा आज नहीं तुम्हारा कल सुनवाई होगी. One more aspect which I as a judge was doing, which would listen your burden, which would listen the burden of the witness, and which at times would show that yes, आज मुझे बुलाया है, मेरी पेशगी आज हो जाएगी. So don't call too many witnesses on the same day. What you should do is, this nobody will tell you. If you have a roster of 10 matters, if your capacity is to examine only 10 of them, then out of those matters, call 3 in each. And as per the old section 319, fix your trial for the whole week. 3 daily. So that you also get disposal. You don't forget the matter. So if you give a date, आज 3 को एग्जामिन किया, कल 1 महीने के बाद 3 को किया. See, at times you become vulnerable to an explanation to be given to the High Court. Why have you not followed 319? Don't call all the witnesses enumerated in the charge sheet on the same day. Why? If you say, I am God, I can examine everybody, then even God tells you. Say, if you go to the temple on a day where there is huge line, you are being told, niklo, 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 niklo. So don't overtake unto yourselves to call all witnesses on the same day. We have to send half of them back. Why? Why this? See, it creates a bad image for you. As well as the exchequer. वो तो आया आज, उसको तो विटनेस भत्ता देना पड़ेगा आपको, तो एक्सचेकर पे पैसा लगेगा. डोंट डू दैट. You have any questions on this topic before I call it a day for this topic? Any questions? I have been often telling people there are only two kind of people who have no questions. One, yes. One, सबके साथ ले लूंगा 11:30 बजे. Wait for 5 minutes. We are closing it. Say, a person who doesn't know anything and doesn't want to know anything, or a person who knows everything. So I would take, because you are judges, I will take you in the first category. That you know everything. Anything more you want me to discuss on this? Sorry. Vulnerable witness deposition complexes, can you tell me? Do you have them in Sikkim?
Yes.
You have them. So you are aware about it. Have the High Court framed the guidelines for examining such witnesses?
Yes.
And you are all aware about it.
We do have pre-trials also of the victims.
So I need not waste my time on your time on that. So there is one aspect which always lurks on my mind. What is the role of the society? हम तो करते हैं अपना. What is the role of the society for witness protection? You may feel, sir, उसमें society क्या करेगी? See, if you see it from the broader aspect, society here doesn't mean all together. It means the non-government organizations who are safeguarding the interest of witnesses. Say, for example, in Zaira Singh, later on it was revealed that it was out of ulterior motives, this, that, blah, 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 that's a different issue. But at times, these NGOs and the police play a vital role. See, what do you understand by the term victim? Any problem? Any discomfort we can tell people here to do the deed? Say, victim compensation under the old Act, CRPC, 357. The new Samhita also is the same. The section differs. It is 395, if I am not mistaken. As I told you, I have not mugged up the new Samhitas, though I have written 2 forwards to 2 national law universities on their Samhitas. But the pivotal role of justice delivery system is requirement of moving ahead, new dimensions, evaluation of new dimensions. Say, till 2012, it was there. हिंदी में तो कहते थे पैसे दो and get yourself scot free. The Supreme Court in Ankush Gaikwad came up with this victim compensation idea. At times, deterrent theory may not work. Say, I may not want somebody to be behind bars. What I want is my money back. Say, for example, if it is, what are 420 litigation these days? Earlier, they were classical litigations on 420. साहब इसने मेरे साथ 420 किया है. It really dawns on your mind. He has cheated me. For that, I don't want him to go behind bars. What I need is a sorry from him and a money for my documents or whatever wrong he has done to me. So this is what I call as a dimension of law which is evolving. Said at times it is not only the Supreme Court or the High Court should evolve law. How many of you have heard the name of Justice Dev? Anybody of you? Anybody of you? Justice Dev, I know him that much. Who's be a victim? I am not telling convict, I am telling accused. Mind me. Can an accused be a victim? How many of you say yes? Raise your hands. Madam says no. My question is very clear to all of you. Can an accused be a victim? No. Why? Then I'll give you a classic example of an accused being a victim of the system. Please give your reasons. Because 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. You are the solitary person. I am also not with you.
An accused can be a victim in another set of circumstances and facts.
So I never asked you to specify. I only asked you a broad spectrum.
Yes, it
Can an accused be a victim?
Yes, in a broad spectrum, yes.
Right? I'll give you the classic example of Vishnu versus state of Uttar Pradesh. With this young boy suffered incarceration for 21 years. The litigation against him was under section 376, as it then stood, of the Indian Penal Code, read with section 2D of the SC/ST Act. Under SC/ST Act, he was sentenced life. The 376, he was sentenced for 10 years. This is on records, I am not telling it from myself. This is on records. When the matter was taken up before the High Court, it was an appeal of the year 2003, filed in the year 2003, through jail, no advocate for him. The matter was listed somewhere in 2021. आपको लगेगा ठाकर साहब घर की कहानी सुना रहे. No, it's there on records. And if you have seen the TV news in 2021, it was on headlines. A man walks free after 21 years of incarceration. To do away with this social bads, you have to evolve a scheme, a system. If social wrongs are sought to be remedied in the streets, then there can be neither peace nor progress. Without progress, the attainment of social justice is impossible. The golden rule in a rapidly changing system, there are no golden rules. This is said by Justice Krishna here in 1977 to SCC 329. Except Justice K.J. Thaker. Say, as far as India is concerned, we are talking too much about our fundamental rights. Do you know that India there prevailed a system where a magistrate would punish a person straightway, without charge sheet, without even FIR, only on a piece of paper? Is anybody ready to believe this? How many of you are not ready to believe this? How many of you are not ready to believe this? I too was not. But this is an incident. All those who are interested in reading books, there is a book known as Famous Judges, Lawyers and Cases of Bombay. Can you imagine there being a book which would have a topic known as misdemeanors of magistrates? How many of you know the meaning of misdemeanor? Misdemeanor का मतलब पता है?
Basically, in simple colloquial word, term would mean bad behavior.
थोड़ा
It would mean bad behavior
Bad behavior.
or doing something which is not.
Can you believe that there can be a chapter in such a book known as famous lawyers and cases of Bombay? Can you believe it? No. There's a chapter dedicated to magisterial misdemeanors. And it does not speak only about behavioral hazard of a magistrate, but how magistrates were giving justice in the erstwhile Bombay state. I am aware only of this, so I am not taking you any further. I'll just give you these two instances within 2 minutes. Under the head note of magisterial misdemeanors goes to show that Indians was so suppressed that even magistrate would not hear the servants of European men and women. ये मेरा नहीं है, लिखा हुआ है. I quote in verbatim narration from page 228 to show that from the years which have bypassed and handed over to us after framing of the human beings belonging to any class of India have been given their basic rights. This was my chapter on when I was delivering on human rights. It seems that in old times in Bombay, it was common for a European man and woman to send their servants to a magistrate. Now, why I am taking this topic is, the end is victim compensation. Therefore, I asked you, can an accused be a victim? With a note complaining of the servant's misconduct. सिर्फ चिट्ठी लिख के आ गया मैडम के पास कि कौशल ठाकर ने ठीक से पढ़ाया नहीं, खत्म, flog him. The magistrate proceeded straightforward to act upon the note, convict the man summarily without any sort of trial and punish him on the spot, generally with flogging and occasionally even with imprisonment. This thoroughly lawless practice seems to have continued till almost the time of establishment of the High Court. Now this is a author. Invariety refers to a case in which a darji is a tailor, employed by a European was punished in this summary fashion with 3 months imprisonment for leaving his master's service without notice. कल तुम्हारा ड्राइवर बोलेगा मैं कल से नहीं आने वाला, हम कुछ कर सकते हैं उसका? If he is in private service. Okay, thank you. I'll have a new one. All that you can ask him कि सर हमसे क्या गलती हो गई? It's the other way around now in this socialist pattern of Indian hierarchies. But the Darji refused to take this outrage meekly. He filed a suit against a magistrate named Cornfield for damages for wrongful imprisonment. Here comes victim compensation. Wrongful imprisonment. The suit was heard in the High Court, and Westrop, who was at that time at the bar, was engaged for the plaintiff. Westrop fought for his client stubbornly, and substantial damages were awarded to the Darji, for he had a just excuse, which the magistrate never cared to inquire. I will take you first to the sexual offences, child victims. Now, what do you consider by the word compensation? Is it only money? See, you people are right. Basically, by the word compensation, when we use the word compensation, all that comes to our mind is money. But according to me, in my definition, it will also partake within itself restoration. So I don't want your money. You restore. So as far as environmental compensations are concerned, at times money is not going to work. You have to restore the system. Awarded to someone in recognition of loss, suffering or injury. Now what is this injury? Has it to be only physical?
Trauma, any trauma faced, suffered.
Say in a motor vehicle case, along with physical injury, my family has undergone trauma. I have undergone trauma. Will I have to be compensated for that? A recent Supreme Court judgment is awarded 10 lakhs for trauma. The word basically, according to me, would mean to amend and to put the person in the same situation or akin to that as he was before the harm was done. Now you have a topic, relevant factors to be considered. So what is the relevant factor? The rational. See, reparations. Why I brought this? It is reparations also. Compensation would partake reparation. REPA, Therefore, restitution. Reparation, restitution. You have to restore. Now, how do you restore? What will you restore? Can somebody tell me? You've done me a harm. How are you going to restore it? कहते हैं ना, तुम्हारा करोड़ रुपया भी मेरा दर्द कम नहीं कर पाएगा. Then how do you restore it? Can somebody tell me? And what is the difference between compensation and damages? Can somebody tell me? At times you see there are phraseologies or English words which seem to be similar, but they have their inbuilt differences. Say for example, if I ask you, what is road? A simple word. So road is Rasta. Rasta is not the meaning, is a Hindi synonym. So at times it becomes difficult for us to recompense. There comes damages. POSCO Act. See, it was United Nations which came out with this idea of compensating these people with known as victims of crime. Now, who is a victim? Your CRPC defines victim: person who has suffered any loss or injury caused by reason of the act or omission for which the accused person is being charged. Now then you would say, sir, then how can an accused be a victim? See, then the accused thereafter, when he is becoming a victim, he charges the accused, the original victim or the government machinery. Says we saw in the British case of the Darji, it was the judge who became the accused in the suit filed by him for damages. Victim includes his or her guardian or legal heir. So who is a dependent? Under the Nalsa scheme, they have defined the term dependent. See, compensation is now an integral part of Article 20. मेरे को पूछो ना.
Kaushal, we just have a query, we were discussing it during our break. For instance, let's say a young girl who is aged about 8 or 9 years has been murdered. For instance, a young girl who is aged about 8 or 9 years has been murdered. She is not working, nobody is dependent on her per se. So, in the event of such a matter, can the parents be given any compensation under the scheme?
You say there is nobody.
No. She has parents, but she is not earning per se.
No, but that
she's
is
not
the
a
word.
dependent.
See, let us be very clear. Under the victim compensation scheme, you don't have to have a person who is dependent. Let's go to your, now that you have put this query, let's go to your no, this is not the 1 minute, madam. Let's not confuse ourselves. 1 minute. Please don't confuse yourselves. There is a word defined as dependent. Dependent. Under section 357, it is not dependent. Please read the word. Victim.
If we,
So I took you to the earlier definition. 1 minute. Please, no, please. See, your cobweb will be removed within 1 minute. If you go to the definition of victim, read it with 357A. Read it with 357A. Fortunately, I have the older CRPC with me. May I read it for your benefit? One minute, please. Will you go to section 357 and then read section 2WA? Which has been brought into the legislation only in 2009. Victim means, please read, no need to go for your Google, it is here. Victim means what? The expression victim includes what? His or her guardian or legal heir. Now, can you say that the mother is not a legal heir? You all four are dealing with MSCTs also.
Lordship may read 2E of the compensation scheme of Sikkim as well. 2E of the Sikkim compensation scheme, Lordship may refer to 2E as well, which defines dependent.
2021.
22.
The Sikkim,
The Sikkim one, no, yes. That is what I told, I'll take you to that.
2E.
that was what we were discussing, the confusion, the dependent.
It includes father, mother, grandmother.
है ना इधर मैडम 2E is very specific. That is what I told. I'll take you straight to your compensation law, your scheme. Forget it. Forget you did not have victim compensation scheme of Sikkim. What does the word victim specify? 2AA. Now let us see 357 of CRPC. When a court imposes a sentence of fine or a sentence of which fine forms a part, the court may, when passing judgment, order the whole or any part of the fine recovered to be applied in defraying the expenses, fine, in the payment of any person of compensation for any loss or injury caused by the offence, when compensation is in the opinion of the court recoverable by such person in civil court. Now C, madam, please read C. Under the Fatal Accidents Act, entitled to recover damages from the person sentenced for the loss resulting to them from such death. Am I clear? Does that remove your doubt on whether parents can be given money or not? Then go to 357A, the scheme. Say, in a matter which was pending before us in the Gujarat High Court, where two young boys in a cricket match received injuries and died. The charge sheet was under 302. And as you all know, all five of you, we as district judges are reluctant in exercising powers under 304 part 1. We normally, भैया हाई कोर्ट करके देगा तुम. Thank you. I don't say we are scared, but we don't exercise those powers. Similarly, the trial judge had convicted those young boys under 302. The prosecution was trying to tell us that, sir, this is post-Bodhra. We said, sir, anything happening post-Bodhra is not related to Bodhra. There is nothing to hype it on such a high pitch. And at that time only this Shivaji Gaikwad, Danu Gaikwad's case had come. Ankush Gaikwad had come. So I asked the council, would you like to take the benefit of that? The parents were more than ready. They said, sir, we have lost our children. They are our neighbors' children. They are languishing in jail since 8 years. without bail and bail bonds. These incidents are not going to recur in the family. We don't mind. I still remember all the parents profusely cried when we pronounced our judgment undergone with 8 lakhs, taking it out of 302 to 3041. So there is that victim compensation. Sometimes, as I told you, the parents may not want the other side to be in jail. Then I gave you one. Delhi Domestic Working Woman versus Union of India, 1995 1 SCC. Compensation for victims shall be awarded by the court on conviction of the offender and by the criminal injuries. This is 1995 1 SCC. Now this is 2014 4 SCC 786. There is a statutory duty upon the state under section 357A to award compensation to the victims of crime. This is a duty cast on the state government. So at times what we do is, say we enhance the fine. Say 5 lakh ka fine, 3 lakhs will be given to the, this is exactly there in the POSCO Act, that the monies can be paid to the victim or the members of the family. Now POSCO Act, that is I think one of the topics for this. So I think your question, madam, has been answered now.
Yes.
Whether the payments can be given. See here, NALSA scheme also says dependent includes. It's an inclusive definition. Same like your 2E. Father, husband, this under the state policy, part 4, chapter 4. See, the Supreme Court has said anything under Article 21, they have stretched it so big now. As I told you, they have considered it as a part of life and liberty under Article 21. Rudal Shah versus State of Bihar, 1983. I told you, Article 21. You can even take these arguments and say, I am awarding. Indian woman says gang rape on orders of village court published in Business and Financial News, so and so. See, that was humiliation, writ large. And there the court gave compensation. Say now the next topic was reparation, rehabilitation, reparations of this child witness. It is a sort of reparation for them. Now the POSCO Act. Unfortunately, the word may is used. Is it to be interpreted as shall? Say under section 354 read with POSCO, Can you award? Why? Because physical or mental trauma. Physical, mental trauma. Section 4(7) says about compensation. The word is may. Who will pay this? Who will pay? Why should the state government pay? Agreed. At the same time, why should I not direct the perpetrator of the crime also to deposit money? Because at times what happens, this was a debate which was there when we had gone for the Juvenile Justice Committee's meeting at a seminar in Delhi. What happens to, say, you are applying POSCO to everybody below that age? What happens when the girl and the boy elope together? Unfortunately, it is considered to be rape. If the girl is below that age. Now what is the ignominy of the young boy who is also an adolescent? Unfortunately, though 3 years have elapsed since we had that conference, requesting the government to come up with some idea on that, nothing has come across. Nothing has come.
Consensual age, because we do.
No, 1 minute, madam. Under 357, make it a part of compensation as paralegal needs. Have you heard this word? Paralegal needs. What are these paralegal needs? See, the family is so poor that it cannot send its child for school. Can you award that? Say POSCO rules permit you this. To award paralegal benefits to the family and the family members. So restorative care, as I told you, has to be considered as a part of compensation. You all have your district legal services authority. You all have your member secretaries whom you can direct to contact any NGO for all these things. This can be a part of your final directive order also. And going back to the victim compensation, a victim witness, you can even give the child a support person. Now, who can this support person be? A social worker, a counselor, or anybody attached with NGOs. you can go to this. This is published in AIR 2000. Not very sure. So take this judgment of Naval Kishore Mishra. Where they have defined the term victim. This. AIR 2019 SC 3352. You have to have your innovative approaches, for. But at the same time, what would be the relevant factors? Can somebody tell me? One of them. One by one. Relevant factor. That will end this topic. Relevant factors to be considered while granting compensation to victim.
Gravity of offence.
इतने आपका टर्न आएगा. Ladies first.
The
Sorry.
social status, Lordship.
One, social status of victim or
Victim, her family.
not of accused. Accused के पास एक पैसा भी नहीं है.
Lordship, in one judgment what I've done is, accused did not have any work. He was workless, but he was convicted. So I have to order fine as well. So what I did is, whatever he will earn from his imprisonment, half he will keep it.
So
and
the
half-
status of the accused, status of the victim, both.
Yes.
Right? Yes, madam.
Age of victim.
Age of the victim.
Loss of employment or educational opportunity.
Economic status of the victim.
Economic status.
The injuries sustained by the victim.
Same as she said.
Mine was loss of employment or.
So that is victim what she has left. What she
Physical
has-
injuries.
Yes, madam.
Medical expenditure incurred,
Right.
damages, Lordship. Mental.
That is same like what she said. Something new.
Lordship, future prospects of what that victim would have done. Future prospects like.
नहीं नहीं अभी तो इनका टर्न बाकी है. इनका बाकी फिर आपका आएगा.
I'm really sorry.
No, there is nothing to be sorry. Yes, madam. Just think over. We'll come back to you.
Lordship, I'll say the same thing, Lordship, the gravity of the injury.
वो आ गया.
And
You are just repeating in a better way. Something new.
Future prospects. Like when.
No, future prospect, but how will you calculate that?
Lordship, basically, when somebody becomes a victim, there's a lot of trauma involved, social repercussions.
Right.
So future prospects, like if we really take a very simple village person, victim, future prospects like marriage, education,
Exactly.
social standing.
This is exactly. See, a rape victim has seldom and gets her chances of remarriage very less. That kind of. Yes, madam.
Actually, I'll take some time to think something new because I think everything has been covered.
No, still 2 or 3 of them are left for both of you to cover. As I told you, young generation has to come up with something new. Have you heard the word empowerment? Will you not empower them? Perspective on giving the compensation or awarding compensation. Now can we go to your Gazette to 2022, the notification which is one of our Sikkim compensation to victims, all their dependent scheme 2021. There is one more thing which I want to delve into it. 25 and 26. There is a huge debate going on. A huge debate is going on. Whether, and therefore you see at times, in our times, under the Scheduled Caste, Scheduled Tribes Act, they would like to compound it. If it was not a major dispute, because normally SC/ST Act, it is either neighbors or you know the person. So they love to compound it. But now what has happened, some high courts have started saying that if it is not conviction, the amount which the government has given will have to be refunded. If you have read live law recently, some high court has taken this stand. Your act also says the same. Section 26. Please read. See, you have 2 chapters. Chapter 1 and chapter 2. Say, let's go by the notification. Applicability of this chapter, which are not covered by chapter 2 of this scheme. See, chapter 2 deals with women's victim compensation fund. So, meaning thereby, chapter 1 would apply to all others. Am I clear? Because it says it will not apply, it will apply to all those who are not covered by chapter 2. Now there, section 17 is more important. Deals with procedure for grant of compensation. Under chapter 2, you have section 24 and 25. Any other aspect you want me to discuss on this? Or you are enough bored now? The appellate judges, would you like me to discuss the niceties of some of the provisions of Motor Vehicles Act?
I'm not dealing with you, what about this?
Yeah, all district judges don't take up.
No, that's it. Three of us are in Gangtok, principal district judge.
So you have only motor vehicle courts in Gangtok only?
In one district, we have 3 district and session judges, 2 are special judges, so they preside over other cases. Only the principal district judge is presiding over the tribunal of that particular district.
Oh. So you'll become a principal district judge someday. No, if you permit, then we may go, otherwise you may go through the judgments which I have given of 2020-24. And I would,
Lordship, I have one question.
what, 1 minute, let me shut this up. For your benefit, I will give you one chart which you can always depend on, which I thought that these 2 topics were so dry that I would finish by one, but I think one topic remains. And you can go through my article on liability of insurance companies with special reference to motor accident claim cases. That's in 2023 journal section TAC. No, Gujarat law report, then I'll give you the Xerox. This is a chart, you can go through it, and if all 5 of you want, I'll give it to you. ये दे दीजिए. What I'll do for you is very briefly go through the guidelines given by the Apex Court as far as liabilities are concerned. Otherwise, these judgments which I have given, they are recent judgments. And I'll 2024 4 SCC also, a TAC, I'll send it to your director who can give you the on your group. And as I told you, the Bajaj Allianz judgment is very much clear now on light motor vehicles. Mukund Devangan has been reiterated to be a good law. And I hope all of you are aware about the Pranav Shetty judgment. Those guidelines you need to follow. That's the law we are present also. It has not been revisited. And for today's judges, you have one good thing that we were always burdened with passing interim orders under section 140. Now that has gone away. So you are benefited to that extent. And one more aspect. Now, I have always felt that once the legislation or the Supreme Court telling that an FIR lodged will have to be treated as a claim petition. How do you reconcile it with 166(3)? The newly amended 166(3) lays down 6 months. Therefore, there is a very good judgment of my brother Justice Pankaj Bhatia from Allahabad High Court. I don't know whether it is a reported judgment or not. Now, can you rely on the income tax return and pass orders? Okay, I don't want to read anything else. These income tax returns are fine of the deceased. If you are not satisfied, go through the judgment of the Supreme Court reported in AIR 2023, page 44. In the case of Anjali and others versus Lokendra Rathod and others.